Many business owners think the risk ends when they close the deal, but often it's just the beginning with the reps and warranties they sign. My guest today help us understand what that really means. Welcome to Business Beyond You, the one-stop hub for insights, conversations, and perspectives business owners need to build businesses that last beyond them. Hi, I'm Sara Vaziri, M&A advisor in the state of California, and today my guest is Addison Adams. He is one of those lawyers who closes deals, and he owns a boutique law firm in California and Orange County, where I am. So, Addison, welcome to Business Beyond You.
Well, thank you so much, Sarah, for having me. It's a pleasure and an honor to be here and on your program. I'm a big fan of yours. Thanks for having me.
Thank you so much. So, one of the things that we as M&A advisors see in our deals is after we get to the stage that we want to draft a purchase agreement, the two lawyers about from both sides, they talk about different things, but one of the most important things they constantly talk about is representation and warranties. So for somebody who has never sold a business, help us understand what is this subject? What do you guys even talk about when you talk about reps and warranties, reps and warranties? What is it exactly about?
That's a great question. I'm happy to explain it. It's a simple way of explaining to the buyer what they're getting. In other words, tell me about your business. Buyers are putting a lot of money to buy the business. And by nature, they are always going to be a little nervous. They want to know, what don't I know? What do I know? Is this business what I think it is? And the representations and warranties are contractual promises, assertions given by the owner of the business that's selling, confirming exactly what's being sold. And so, for example, a common rep and warranty would be attached are my profit and loss statements and my balance sheet for the business. They're accurate. I've done my best to put forth the right numbers. I'm not inflating the revenue. I'm not hiding any expenses. So that would be usually a paragraph long that says the financials are attached and here's what they are. Other things might be, for example, um, there's no litigation pending. I'm not suing anybody and no one's suing my business. Or if there are some lawsuits going on, the rep and warranty will say, we're getting sued by this former employee that we fired. That's the only thing that's going on. There's no other lawsuits. And so the reps and warranties, they really fill um, an opportunity to supplement the information the seller's already shared with the buyer through the due diligence, where there's been this question and you've given copies of contracts and you've answered all their questions. You've met face to face with the buyer and explained about your business, told them how many employees. And then this is where it all gets written down and confirmed as part of the sale contract.
Mhm. So it's kind of highlighting the most important assumptions the seller is showing a buyer, and buyer's offer is based on those items. It's like their promise that I'm promising you these items will be correct and you can count on them, something like that.
That's correct. That's correct. And that's where things can get a little more nuanced as far as what is the nature of the rep and warranty, what's the promise. And so as a seller, typically you want to put what's called a knowledge qualifier on everything you're saying. Going with my last example, you might say, there's no lawsuits against my business that I know of. And that might be true, right? You don't know of any lawsuits, but there might be a lawsuit on file that hasn't been served that nobody's told you about yet. And so one of the questions is, does the rep cover unknown lawsuits or only the ones you know about? And this can apply to all kinds of different things, regulatory investigations, health department violations. From a buyer's point of view, they'd like to get a rep that is unqualified, that just says there's no lawsuits, there's no health department investigation. There's no environmental, grease trap leaking under the building. There's nothing going on. And if there is, then that would be a breach of the rep and warranty because now it can transition from I'm telling you the truth, I'm telling you everything I know, to I'm giving you more of an insurance policy that says if this is wrong, even if I didn't know, I'm going to pay for it. And
Mhm.
so that distinction is one of the areas sometimes for negotiation from between the buyer and the seller.
So if you are on the seller side, you would do your best to narrow it down, and in the buyer side, you'll try to expand it as much as possible. That's why the lawyers from both sides, they need to be there to kind of protect their clients.
That's right. That's right. It's interesting because buyers and sellers, of course, are completely opposite interests. From the buyer's point of view, they want full guarantee, full warranty. Everything is exactly as presented without variation. I want no risk. And if there is a variation that's bad, I want the seller to make me whole. On the seller's point of view, they'd rather say, I've run this business for 20 years. It's a great business. It's solid. And here it is, as is, no promises. Meaning I'm obviously not
I'm
lying to you. I'm not
guaranteeing
hiding anything,
nothing.
but also I'm not making any if something pops up, even if it's from the past, take it as is. And, sometimes deals happen on an as is basis, extremely rare, because the seller knows their business and the buyer doesn't. And so that's a lot of risk for the buyer to try to assume. And so then we end up with this process of reps and warranties. By the way, buyers give reps and warranties too. So you'll see in the contract both parties giving reps and warranties to each other, but they're not the same. The buyer's reps and warranties, usually three or four, along the lines of I got the authority to buy this business and I've got the money. And the seller's reps are all, I have the authority to sell the business, but then it goes on and on about the business itself,
All of
which
the
is why there's a
details of the
lot
business.
more. Yes.
And apparently there is a disclosure schedule, something like that, that you add them somewhere. What is that? What does that work?
Yeah, sure. So the idea here is to provide detailed reps and warranties. Selling a business is a very sort of granular thing because a business is it's not like selling a car where you say here it is. It's a group of employees. It's a list of customers. You've got this, sometimes inventory. You've got all kinds of things that are making up the business. And so looking at it one point, one piece at a time is oftentimes where the reps and warranties will come down. So there'll be a rep around the employees, a rep around the inventory, a reps around the customers. Here's my top 20 customers. And so what I just said is where a schedule would kick in. So the rep might say, attached to schedule 2.2 is a list of my top 20 customers. And then you go to the schedule and you flip to the page and there's a list of 20 customers there, as an example. Same
Mhm.
thing with employees. You might say, oh, I've got 14 employees. And then there might be a schedule that lists them out by name, how much they make, per person, what their job title is, that kind of thing. Um, and so disclosure schedules, sometimes they're also called exception schedules. So
Mhm.
my example earlier about the lawsuit, you say we don't have any lawsuits against us and we're not suing anybody except for what we've listed out on that schedule.
And
And then you
disclose
list
it
that
there.
one lawsuit from the employee that got fired,
Got
who's
it.
suing for wrongful
Got
termination.
it.
Yeah,
So
so that's how.
how many times, because a lot of times sellers think that, okay, I'll sell my business, I go out completely. So how many times you see that the buyers come back and they have some kind of problem with the business they have bought, and those reps and warranties really help the seller defend themselves. Is there any example you can give us?
So I've done some expert witness work in my career as a mergers and acquisitions attorney, advising on cases where things have gone wrong in a transaction.
Mhm.
And so what I will start by saying, when both the buyer and the seller use an attorney, um, and if there's a broker involved, this also helps. Um, the odds of having a dispute, a lawsuit, or even a demand letter after the sale closes goes down dramatically. Most deals are good deals. They stay good afterwards. And that's part of my job as the attorney is to not only make sure the client gets what they want, but that they're protected. And part of protecting them is making sure that the buyer is not surprised afterwards. And so a big part of these reps and warranties that's helpful is making them accurate, which lets the buyer know what's coming. And so if they were, if all they have to do is read the contract and read the schedules, and they will know what's on there. And the more that's on there, the less opportunity there is for a surprise. And surprises lead to lawsuits.
Mhm.
And
So most
so,
of those cases you saw there wasn't lawyers involved or
so I've seen situations in those cases, there either was no lawyer involved or there was a lawyer that was a friend of the seller or a friend of the buyer that
or
was,
wasn't an M&A lawyer and didn't know anything about the whole M&A
well,
process.
yeah, I would say there's there's the I'm doing a favor concept, but also sort of phoning it in and not really participating actively, not really paying a lot of attention and having a lot of conversations with the client. And so things can get missed that way. And then, of course, there's the other problem, which is the jack of all trades lawyer that's trying to do, everything under the sun. And even though lawyers can do everything under the sun, we tend to specialize and get really good at the one or two things that we're specialized in. And so,
Yeah.
as an attorney doing this for 30 years, I'm definitely specialized in buying and selling businesses. And you get good at it. You just get that nuance. Yeah, so
Yeah,
it's
unfortunately,
hard for me
that's
to
one
give
of the
too.
hardest part of our job. Like the seller has a close lawyer friend who wants to help, but when they come in, you go, okay, how do you want to help? Yeah, my experience is in court. I have done trials and I have never seen an M&A. It makes our job really, really hard. So that's one of the things we always try to do. Please, please bring a M&A advisor, some M&A lawyer, experienced one who can help you. Otherwise, it will be a disaster for us.
I've had plenty of those experiences too. That's I always want the other party to have an experienced attorney in M&A because otherwise my bill will go up. The time I spend negotiating with things that we shouldn't be negotiating because they're asking for non-standard, they don't understand the transaction and how it works. And so but they're trying to be aggressively representing their client and kind of going by gut. And so that ends up, all right, I explain to you why this doesn't make any sense and it's unfair, and you start doing that more and more, and you're just, you're spending time. So having two
Exactly.
experts, everything goes smooth, which is
Exactly.
great. We just go straight to the, you know, is this going to have a knowledge qualifier or not on that rep and warranty? And it helps when
Exactly.
the other person knows what you're
They know
talking
what to talk about, what are
about.
norms, what are not.
Yeah.
So back to the concept of reps and warranties, does do these reps and warranties last forever, or what is the survival period for them? Tell us a little bit about that. A business owner who sells the business, until what time these reps and warranties last?
It's a great question. And so what we're getting into now is a different section of the contract, which part of it relates to the reps and warranties. And so most sale agreements include a section on indemnity and liability. And
Mhm.
so the concept here is to say there's different kinds of liabilities that come with the business that you may or may not know about. And so as an example, let's say the buyer is buying the stock and taking over the entire corporate entity, and that corporation has an obligation to pay taxes. And let's say that There's a rep and warranty that says all the taxes have been paid, through the closing date or everything that's due has been paid. And we'll take care of paying whatever's extra through the closing date. And then after the closing, the buyer finds out that there's some unpaid taxes from a few years ago. And because they run with the corporation, um, that buyer needs to pay for it. It's a corporate obligation as opposed
Mhm.
to a personal obligation. And so the rep and warranty oftentimes gets broken down into two different sort of categories. You're going to have what's called fundamental reps and warranties, such as the seller owns the business and has the right to sell it. There's not going to be some third party that shows up and says, actually, I own the business and they didn't have the right to sell it.
Mhm.
And something like paying taxes of the corporate entity. So those are two examples of a long term where basically that promise stays forever. Usually it's described as the applicable statute of limitations under the law, maybe
Mhm.
plus 90 days, so that the buyer is never going to be out of pocket for that kind of a problem. And then you have the other reps that are more like talking about the performance of the business, for example. The income we made the last 3 years is what I said it is. Or the question about the employment liabilities or employment lawsuits, things like that, regulatory investigations. All of those are sort of backward-looking historical, statements, and typically they would have an expiration date, and that expiration date is usually 12 to 24 months. This can be negotiated, but the idea is once you're beyond that window of time, if a claim pops up that shows that that rep and warranty was wrong, it's too late. The buyer just has to take the financial hit and move on. And so
Mhm.
the idea there is to give the seller on most of these reps and warranties, but not the fundamental ones, closure where they can stop looking over their shoulder and eventually go ahead and
They
spend
know
all the
that
money.
they're finally safe and out of this.
They're finally safe and out of this. Yeah. And sometimes that duration idea can be linked to obviously shorter is better for the seller, longer is better for the buyer. A lot of times, but there's going to be seller financing in a deal. Um, and so that might be paid over a few years. And so buyers can sometimes try to negotiate a longer time period to track whatever the payment obligation is on the seller note. And as well as a right to sort of offset any amounts owed on that note if liabilities pop up later.
Mhm.
Um, and then it used to be in the case, although this has sort of gone away with changing, trends, is buyers used to put money in escrow and it would sit there in escrow for a year or two and adjust for liabilities that might pop up. And then if there was a liability, it would be paid out of escrow, and then whatever's left at the end of the 1 or 2 years would be released to the seller. These days, sellers tend to just do that financing note and give more of an IOU rather than actual cash in escrow if it's going to be
Mhm.
held for a long time. Although
Yes.
sometimes it does happen, especially if you've got any kind of, well, credit risk of the buyer is number one concern for the seller if they're not getting paid in full at close. So, but that's a whole nother topic.
Yes. And I know this is a topic that we can talk forever, but we are short in time. As a last question, if you can touch on this subject of how different is reps and warranties when we have a stock sale versus asset sale, that would be great if you can talk briefly about that one as well.
Sure. Happy to do that. You'll see that there's actually a lot of overlap. The reps and warranties about the business, about the authority to sell, are all the same because same issues, right? You need to know what you're buying, and need to know if there's risks, potential liabilities, or actual liabilities that are there. Um, on a stock sale, there's more interest in the sort of chain of title of each share of stock. Now you're doing the agreement, the purchase is with the shareholders, or if it's an LLC with the members. And so they're the sellers of the ownership, the share or the membership, as opposed to in an asset sale, which is a little more common, where the seller is the entity, the LLC or the corporation itself. And the money is going to them and they're selling the assets and the contracts and the goodwill and everything
Mhm.
from
So
that. So
everything is prepared based on this main difference.
yeah, so tax wise and structure wise, it's totally different, including who the parties to the contract are on the sell side. Um, the reps and warranties, though, they get customized somewhat around ownership of the shares that are being sold. But otherwise, a lot of it is exactly the same.
Okay, thank you so much, Addison. Thank you for coming and sharing your knowledge with us. I know this is not a subject you can talk about for 20 minutes only. There is so much to talk about, but it was a brief. We just want to give an introduction of the subject. Please tell us how they can reach out to you if somebody needs help from an experienced M&A lawyer in their own deals, how they can reach out to you and briefly about your company. That would be great.
Well, thank you, Sarah. I would be happy to talk to any of your listeners. I provide free consultations. We can do a phone or a Zoom call. And I have a website. It's www.adamscorporatelaw.com. My phone number is 714-619-9360. And my email address is addison@adamscorporatelaw.com. You can also find me on LinkedIn under linkedin.com/n/Addison Adams, the lawyer that closes deals. Would love to work with
Awesome.
you and with all of your listeners. Thanks.
Thank you so much. And we will definitely add your information under this video. Thank you again for joining us in this episode of Business Beyond You.
Bye bye. Thank you.
Bye.